So I think we are live. So welcome everyone to this privacy rules event. The title of the event of today is Biometric and Privacy, a 360-degree analysis across the Americas. My name is Alessandro Di Mattia. I am the director of the Privacy Rules Alliance. And to achieve an event like this, we took advantage indeed of our network. Privacy Rules, just to give you a little introduction on us, it's a global alliance operating over 50 countries worldwide that connects local law firms together with crisis communication and cybersecurity experts in order to provide combined joint services all over the world. Before we start with the first session of the event of today, I'd like to share with you a couple of quick reminders. The first one is today we have exclusive access to an AI translation tool, which is named Intertraduction. You can find a QR code to access it in the screen, should be on the top left of the screen, but we will also share a link through the chat. So feel free to use it if you would like to hear these sessions either in Spanish or in Portuguese, for example. Another thing that I would like to remind all our listeners of is please engage with the audience. There is a chat feature, either if you are following us on LinkedIn, YouTube, or through our website. Feel free to use it to make questions and interact with the panelists. We will do our best in order to make you, joining us live. Without further delay, I'd like to introduce to you the first panel of the day, where we will be receiving an overview on the regulatory landscape, in particular of three countries, which are respectively Canada, Brazil, and Mexico, from which we have some news that we would like to share with you in relation to the topic of biometrics. And to do that, I'm pleased to introduce you to our moderator of the session, but also member of the Privacy Rules Alliance for Canada, which is Lindsay Vassar, partner from the law firm Macmillan. Together with her, we will have two other experts that are, first of all, Luiza Sato, partner at Tossini Freire Advogados from Brazil, and Isabel Davara, partner and founder of Davara Abogados from Mexico. So I'm pleased to leave the floor to Lindsay, Luiza, and Isabel. Thank you all for joining us today.
Thanks so much, Alessandro, and welcome to our audience. We're so glad you could join us today for this discussion on biometrics. There's a lot to cover, so I think we'll just jump right in with an overview of the general framework for regulating biometrics in each of our countries. I'll start with Canada. Some of you may know that Quebec is actually the only jurisdiction in Canada that has specifically legislated biometrics. Quebec has an act called the Act to Establish a Legal Framework for Information Technology, and it requires that organizations must report to the Commission d'Accès à l'Information de Québec, or the CAI, any use of biometrics to verify a person's identity, as well as the creation of a database of biometrics. And the CAI can actually prohibit an organization from creating a biometrics database if it considers it to be a violation of privacy. This Quebec legislation also sets out a number of rules and restrictions related to biometrics, including that express consent is needed to collect this type of data if you're using it to verify or confirm a person's identity. Also, biometrics cannot be collected to verify identity without a person's knowledge, and the organization must only collect the minimum characteristics necessary to identify the person. Quebec law provides that organizations cannot use any additional information that's revealed by the biometrics for any purpose. So, for example, if the biometric reveals an underlying health condition, this can't be used for any purpose, and it also cannot be shared with the individual whose biometric data was collected unless they request this additional information. In addition, biometric data must be destroyed as soon as the person's identity has been verified or when the purpose for verifying their identity no longer exists. Although Quebec is the only jurisdiction in Canada that has specifically regulated biometrics, biometric data is also considered to be personal information under all of Canada's private, public, and health sector data protection legislation. So it does have to be handled in accordance with those laws. And both the Office of the Privacy Commissioner of Canada, or the OPC, and the CHI have issued guidance on how organizations must handle biometric information for compliance with these statutes. In the case of the OPC, they've issued separate guidance for the public sector on handling personal information that constitutes biometric data in accordance with the Personal Information Protection and Electronic Documents Act. So that would be for the private sector. And for government bodies, they've issued guidance on handling this information in accordance with the Federal Privacy Act. The CHI has issued one guidance document for both public bodies and businesses, which outlines the principles for handling biometrics in accordance with Quebec law. Now, the guidance issued by each of these regulators is quite detailed. So if you are processing biometric data of individuals who are located in Canada, I would strongly recommend that you reveal these guidance documents in full. But one key point that you should be aware of for Canada is that biometric data is considered to be sensitive personal information. So this means generally consent must be express when you're collecting biometric data, and you have to apply a high level of safeguards to protect this information. But also, organizations in Canada have to consider whether they need to collect biometric information at all. Because if they can't justify that there is a serious and legitimate purpose for collecting the information, it's not allowed even if individuals do provide their consent. So in order to justify the collection of biometric data, organizations typically must be able to show objective evidence of a problematic situation that they're trying to address, or a bona fide business interest that's not based on speculation or a prospective problem that has not yet occurred. They also have to demonstrate that the biometric system that they want to use will be effective to address the needs that they are trying to accomplish, including taking into account the error rate of the system and the risks that the biometric technology could be compromised or circumvented. Then they have to consider whether the benefit to the organization is proportionate to the invasion of individuals' privacy and whether the biometric system is minimally invasive. So this requires considering less intrusive alternatives and also the features of the system. So for example, whether the biometric data is immediately and irreversibly converted to a code that cannot be reverse engineered to recreate the biometric, or whether the biometric scan is actually retained in its raw form for any length of time. Only after all of these factors have been considered can an organization collect biometric information, and only if the analysis shows that it's reasonable and necessary to do so in the circumstances. If the organization does then proceed to collect the biometric data, then it must be handled in accordance with all the general requirements of the privacy statutes that I've referenced. So that's a high-level bird's eye view of how Canada regulates biometrics. I'm going to turn the floor over now to Luiza to tell us how Brazil regulates biometric data.
Sure. Thank you, Lindsay, to be here with you. So in Brazil, we also don't have dealing with biometrics. We have our general data protection law regulates the processing of personal data in general. And just as Canada, biometrics are considered as sensitive data. So this means that under the processing of such data would happen under strictest, but differently from Canada, we have other legal basis than so we have consent as the main legal data of biometrics, but we also have other legal bases like performance of a contract, legal obligations, but we also have higher standards of security and more robust governance obligations for the processing of this kind of data. Last year, the ANPD, which is our data protection authority, issued a guidance on biometrics and facial recognition, but it's like a preliminary study, nothing really binding. But this year, the ANPD opened a public call for contributions to develop Brazil's first specific regulation on this matter. And the consultation covered different blocks. First one, definition and principles, and then the legal basis that we specifically for the projects. There's also a specific block only referring to facial recognition and emerging technology. Another one for security, good practices, and governance, and data subject rights and vulnerable groups. It is really going on here is what is considered actually biometrics. We have people saying that, well, any video like this photograph, would it be considered biometrics? And regulation should detail a little bit more about this. A simple image or video cannot be automatically considered biometric data. It would only become biometric data actually capable of extracting patterns or parameters that uniquely identify an individual. And as for the consent, as I said, it will be the main legal base, although there are other legal bases that could base the processing of biometrics data. But as to consent, we have challenges because there's a debate on how a consent can be actually freely given in certain contexts when processing biometric data, especially when there may be imbalances of power or limited alternatives for the data subject. But that's all we up to this moment, Lindsay.
All right, sounds quite similar to Canada, although again, some nuances as there often are across jurisdictions. Isabel, how about Mexico? Is a similar approach taken in your country?
It is. Thank you, Lisa and Lindsay. Thank you, Luiza and Alessandro and Privacy Rules for the invitation. It's a huge pleasure to be with you today. It is and it's not. I mean, Mexico doesn't consider biometrics under sensitive data up to date, but in the law, although in the law applicable to private sector, because we have to remember that in Mexico we have two different orders, one applicable to the public sector and one applicable to the private one. I will focus on the private one because it's the one that I guess is more interesting to our audience. But as you were both mentioning, when we compare Mexico's legal principles and the previous authority guidance, which I will mention after, it's very similar to the European GDPR, the Canadian regime, and the EDPB's biometric guidelines as the Brazilian regime, and we see a common foundation. We share the same principles, and when dealing with biometric data, which, as you were mentioning, is still to be defined what a biometric data it is, and as Luiza was talking about, the same principles that you were mentioning and that are required by GDPR and your jurisdictions are required in Mexico, although they are stricter when you are dealing with biometric data or with sensitive data, which are not recognized as sensitive data yet as today. Although this guidance I was mentioning to you, the guidance that was issued by the previous authority, rule in that direction, and the interpretation of the authorities is as well aligned in that direction. What does mean? We still don't have under the law this the regime of the legal basis. We are still running under the principle of consent, and the consent needed would be the one that you have mentioned, the more specific and written and expressed, in case they are considered as sensitive data. I mean, in case they can provide, or they can make, or they can cause an irreversible harm to the individual. So even if as we are in this huge institutional change that we are going through in Mexico, because we have to remember that the previous authority, which was the INAI, was disappeared in March this year, March 2025. The new authority has inherited and is applying the institutional guidance that the INAI left. And the one I want to mention is the biometric guide, which is one of the most in our very sophisticated technical documents in terms of biometrics in the region. This guide, which leads how the authority applies the law, recognizes and explains how the biometric systems function. They highlight risks such as false positives, false negatives, accuracy disparities, and demographic bias, for example. Emphasize as well that these systems are inherently probabilistic and therefore must be evaluated carefully using principles of strict necessity and proportionality. It also recommends evaluating whether less intrusive methods could achieve the same objective before biometrics collection is chosen. Although impact assessments are not required under the private laws, the private sector law, this guide recommends risk analysis as a best practice for complex biometric deployments. This technical reference continues to serve as a valuable compass for both regulators and organizations. So to sum up, I would say that the regime, if biometrics is not recognized as sensitive data under the private sector law, in practice is how the authority sees the use of this data, as we will talk in more in detail after. So I would say that's it.
All right. Thanks, Isabel. Well, it sounds like Mexico takes quite a similar approach to Canada. And I think one of the takeaways from all three jurisdictions that our audience should be aware of is you can't rely on looking solely at the legislation, which may look silent in some cases, but you've got to really think about and explore and read in detail the regulators' guidance, either already existing guidance or it sounds like there might be some additional pending guidance in Brazil. So do make sure that you understand the position regulators are taking, not just looking at the plain wording of the statute, because you're going to miss important requirements. Now that we have the general framework for each of our jurisdictions, I think it would be helpful for our viewers to understand whether there are certain scenarios